Very nice intro. Thank you, my dear colleagues in Florence, to bring us into this event. It's already the second time of the new season that Lucilla and I are hosting this FSR Insights event. And as always, we have academics here around this virtual table. This time, Lucilla suggested, why not focus on the topic of climate litigation? And I said, yes, why not? You're the lawyer. So who do we invite? And she said, let's be ambitious. Let's really take two of the most renowned experts in this field. And they both agreed to join us here online. So I'm very happy to introduce you to Professor Michael Gerrard for Columbia University and to Joanna Setzer, who is assistant professor at London School of Economics. And they have been also very kind in giving us a short intro video to the topic. And I know many of you already watched it. I saw this morning there are 200 views. So if you didn't yet watch it, I'll really encourage you to have a look. Why? Well, I'll just give a few highlights of what I learned from watching both videos. I started with the one of Joanna. I learned that she has a database, and actually Michael has one as well. It seems they are even collaborating for this database on the different cases. And there are many cases and also quite diverse cases. Some of them are against the governments. Joanna mentioned the taxonomy of systemic specific acts or authorization of third-party type of cases. She also mentioned that regarding companies, of course, there are cases against the carbon majors, agriculture, financial markets, even regulators, which I also found interesting for our audience. Then browsing in the video of Michael, I learned that he is really the expert on the US cases, and that initially, you know, the US was taking most of the cases, but the rest of the world is catching up. What did I learn from his video? Well, on the US cases, there has been quite some focus on environmental impact assessment and to what extent these are done adequately or not. Do they take into account climate impact? I also learned that some cases were about delaying Trump in whatever he was trying to do. And then again, cases against companies. And the cases against companies seem to be also an issue on whether they will be treated at national courts, right? State courts in the US or federal. Seems that the ones that are trying to get the cases want to treat them more locally, because at federal level, it seems to be there is a precedent of these cases being just discarded. Then I learned that the arguments being used in these cases are also evolving. I learned about something, prayer for relief, failure to adapt, also quite recently, but I'm sure we will find out more about all of this topic in this discussion, because the great thing about having the videos is that we can spend most of this hour on discussing. And the way we will organize the discussion is, well, first, of course, Lucilla as co-host will ask questions. And then we have also invited a younger researcher, in this case, Mario Pagano. Mario is a PhD, last year of PhD, I think, at the EUI, and he's an expert on environmental justice and environmental law. So he's perfectly capable of, you know, asking some interesting questions here. As always, dear audience, we will also make sure you can ask questions. So don't hesitate, even when we're in the first part, to already submit your questions, either in this chat box or in the Q&A box. And Lucilla and I will do our best to pick them up and to put them to our experts. So I think I've said enough as an intro. Then I'm looking at Lucilla. Will you kick off the questions?
Thank you, Lau. Thank you so much. Thank you for the speakers for their availability. And it's the best thing indeed, as Lau said, is that we could have 1 hour of discussions in these events. So I will leave the floor to start it with Mario as our guest. So Mario, go ahead and with your questions, what you have in mind.
Sure. Thank you very much, Lucille, and thank you also, Leonardo. And thanks to the Florence School of Regulation for having me, for inviting me. It's a great pleasure to see again Joanna, to meet Michael. My first question, of course, all questions, as Leonardo recalled, are addressed to our speakers. So in both videos, the speakers stress the fact that most cases are brought to the U.S. courts. It also seems like that most cases brought by NGOs in the US are not successful cases, didn't bring favorable outcomes in the end. So I was wondering whether the rigidity of the judiciary in the US can be one of the reasons why civil society actors, more broadly speaking, try more and therefore mobilize US courts more. This is the first question. Thank you.
Well, so let me start by saying that I'm not sure that I agree that most cases brought by NGOs are unsuccessful. It depends on the kind of case. Many cases were brought by NGOs, as was mentioned, against the Trump administration to try to slow down or stop his efforts to revoke or weaken environmental regulations. Many of those were successful, largely because the Trump administration was very sloppy in following the necessary administrative procedures. But the US courts have been very slow to adopt new rights. Some European courts and courts in other parts of the world, as Joanna has very well documented, have been much more willing to declare new rights. In the United States, the decisions that are successful are mostly in cases that have been brought under particular statutes, like the Clean Air Act or the National Environmental Policy Act. But the US courts have mostly not been sympathetic to constitutional claims or rights claims or other things on climate change.
Sorry. Yes, so it's great Mike already gave this first understanding of the particularities of the US. I think I would go back to your question, Mario, and say there are different ways of looking at this question. The one is when in time, and then what jurisdiction, and also what type of cases. So when we do that analysis of outcomes, we're putting everything together in a bucket outside of the US. But I'm now telling you, maybe it's interesting also to focus. So for example, there is a paper that has been published by McCormick and colleagues in Nature in 2018, where they look at success of US litigation until that time, moment in time, by different types of cases. So if they're dealing with different environmental acts and the Cleaner Act, and so on. So if it's a case dealing with renewables, the chances of NGOs bringing and winning is higher than if, so that's the kind of more granular analysis that you can do that will show different types of chances of success of cases brought by NGOs. So I would suggest that it's an interesting question, and particularly if you look at jurisdiction, time, who's bringing and what basis. But if you then put everything together, the interesting finding that we have so far is that litigation outside of the US has tended to be more successful, so more aligned with climate goals than litigation in the US up to that point of the McCormick paper, which was the last time that such analysis was done. But a lot has changed, as Mike said, especially in the Trump administration. It has been easier, and the Sabin Center has published an article on that, on how they have had more success reverting those deregulation efforts of the Trump administration because they were so bluntly illegal, unlawful, that it was easier to revert. And I think maybe added to that, we're also getting, and I think that's interesting, to a point where climate litigation is better known, that we have more cases of success, and that judges are becoming more open and qualified even to decide on those cases. And all of that is also gradually increasing the chances of success, not only in the US, but outside.
Mm-hmm. Interesting. I thought it interesting the question of Mario, indeed, because both of you started your lecture speaking exactly, bringing the same data about the numbers, and US indeed with 76% of the case were indeed a remarkable difference comparing with the rest of with the other countries, including EU and other countries. But my question here would be not, I would shift it a bit to perhaps what we could expect from the audience of Florence School of Regulation would be interesting. So most of our audience is composed by energy regulators, staffs and research people working directly and indirectly in energy utility companies. And as you point out in your lectures, they have like many cases, climate change litigation against corporations that exactly target them. So it's impossible to escape from this kind of questions. And when you speak about electricity utilities, and Michael pointed out very well in his lecture, it doesn't only include oil companies, but as well for electricity utilities, or the gas power plants, thermal power plants. So the question is, and when you come with, you both mentioned about strategic litigation against the corporations, and you mentioned about the strategic against the greenwash behavior, misleading advertising, and compensations for effects of climate change, corporate due diligence. But one that I think really addressed, attracted my attention, it was the one that you mentioned, the most presented one, which is the failure to adapt it. And the most presented, what we have seen in the energy sector and it has been in the news, is the energy crisis that we are facing. So prices of electricity, especially gas, has skyrocketed because of several unforeseen events. Texas can explain a bit what happened. So the question perhaps I would have, and I think most of regulators would ask it as well, it's to what extent these companies in this kind of contest, there is a chance of they being responsible for the failure to adapt it, or perhaps being more precise, what can be kind of the limit, the threshold between, you speak about corporate responsibilities, being responsible for the failure to adapt, and the government failure to change the energy market system as well. So this would be my question.
Well, I guess I'll start by saying certainly in the U.S., there's litigation is not an opportunity to go after the government for failing to modify its energy regulatory system. That is the job for Congress to do. So far, we see a relatively small number of these failure to adapt cases, but I think we will see more and more. Certainly the wildfires that occurred in the Western U.S. and have led to a lot of litigation in Greece and Australia, Siberia, lots of other places around the world. And when these lead to explosions or the release of toxic materials or a lot of property damage or loss of life, plaintiffs' lawyers will be looking for someone to sue, which is always the case when you have serious injury. And energy companies and others that have not prepared for these extreme events, that even though they're extreme, have been predicted by the climate scientists, that they become more vulnerable to legal attack as the scientific projections become more specific, more geographically specific, and more alarming. It is easier for the plaintiffs, for the people bringing these lawsuits, to claim that the companies should have anticipated this and should have prepared for this. So I think we'll see much more of this kind of litigation.
Yeah, I think what's fascinating about this failure to adapt litigation is that exactly as Mike said, there you have one type, which is this one that you should know about, and you have as an operator, an energy operator, or if you own a platform, oil platform, or if you have buildings by the sea coast. So all these areas that are more vulnerable, that you have now enough science and data and predictions to know that these will be affected, and therefore you have to prepare your infrastructure for that. New infrastructure, existing infrastructure. So the question of what are you doing to climate proof what you have from the impacts of this more severe type of weather event, for example. And this is where the PG&E case in the US is really fascinating. Some people have called it the first climate bankruptcy in the world. And it's not 100% due to climate change, and it hasn't been in the existing litigation established as so, but it is possible to understand that case in such ways. What is, I think, also interesting is another side of the failure to adapt cases, which is the failure to adapt investments. So here we're talking about, for example, boards of directors and trustees that are in this position of power and that are failure to read the transition that is being asked to address climate change. And by doing this, they're not investing accordingly with that in mind. So failure to adapt both in direct infrastructure, but also a failure to adapt your decision making, a failure to adapt how you invest, a failure to adapt how you read the transition to a low carbon economy. And when I say failure to read the transition, I'm talking about, for example, anticipating that governments will legislate in a certain way to reduce emissions that will affect your business. And therefore, if you're not anticipating that, you're failing to adapt to that type of shift. So it's not the adaptation as we usually talk about in terms of preparing for vulnerability in direct climate impacts. But I think you can also think about this need to adapt decision-making processes and investments, which is kind of a different side that might be of interest of some of the participants of this event.
I think it's
I agree with that. If I may just add, we do not yet have any judicial decisions holding corporate directors or officers personally liable for failure to adopt or for greenhouse gas emissions. There have been several attempts to do that. I think some such lawsuits are in preparation. There are a couple that are pending, but we don't yet have any actual judgments against officers and directors.
Exactly, and it's interesting to think about litigation, climate litigation as a risk of climate litigation. So how you observing the trends and what type of discussions are having, or even letters that are sent by NGOs to insurers or to investors, you start seeing this increasing litigation risk emerging, and how different investors and insurers are observing closely what's going on. So we've got to a point that climate litigation is not just some niche, strange area of law that some people are playing with, but it has become something that called the attention of much higher levels within companies and governments, to an extent that you might not have a case like that, but there is already an anticipation or a consideration that there is a risk of such case. And that in itself might create behavior change, which is, I think, a really interesting side that it's hard to keep track and measure, but that we can already say that is happening.
I absolutely agree with that. Let me just say that I practiced environmental law in New York for 30 years before I became an academic. And I observed several instances where NGOs or others wrote sort of warning letters to various companies. And they never got into court, but I can tell you that these kinds of letters really can have an impact. That if there is a serious threat of a lawsuit, companies become very interested. You really get their attention that way. And so the threat of litigation, as Joanna said, you can't quantify, you can't measure the impact that it has, but it has a real impact.
It's extremely interesting what you're saying exactly for the public, because usually what you can see is companies relying on the fact that, for instance, the market needs demand. So what they are doing is the securing of supply. And what you're saying is like, yeah, but the fact is that they have enough scientific evidence to predict that it's going to happen. So they could not be excused from the responsibility in this regard. Is extremely interesting. I would leave it at that to Mario.
Yeah, and actually it really relates very much to the next question I wanted to ask, but it's precisely on change of corporate behavior that Joanna just mentioned, basically. And I want to focus once again on unsuccessful cases, because in the presentation that were published, it was mentioned that some unsuccessful cases still led to state policy change or corporate behavior change. And I have a question on causality, basically. which is a problem for climate litigants very often, but it also is also a problem for researchers and academics working on climate litigation. And precisely, I wanted to ask, how did you manage to trace back the policy change or the corporate behavior change to the outcome of the unsuccessful case that was brought? And more broadly, I have if I may follow up, more broadly, I have a question on how do you trace the impact, basically. I know you are often asked questions on impact, and I don't think we can avoid asking these questions even in this forum, but how do you basically track the impact of litigation on climate laws, and to what extent these laws changed after rulings were issued by courts?
Joanna, do you want to start with that one?
Yeah, I can start. Well, it's a huge question, and it's also one that we still don't have all the answers to. So I'll begin with the question on impacts. There are a few issues there. One is, I think there are two groups that are particularly interested in understanding the impact of litigation. Three. One, the litigators themselves, because after all, they're either thinking of bringing that litigation, or they brought and they want to know what happened with their effort. And others that might then consider bringing because whatever someone else did had that impact. The second group is funders. A number of these cases are being funded, for example, by philanthropic foundations, or now more recently, we're even starting to see, crowdfunding for specific cases, and even funds that fund litigation. And all of these funders or investors, or even just people who are supporting litigation, will at some point want to know, well, was that worth it? What is the impact of that case that you brought? And then the third group are researchers, because we're just interested in observing what's happening in the world. We see that litigation is becoming bigger, and it's like, okay, why is it happening? How is it happening? What are the impacts? So I think these three groups are generally interested in understanding impact. Perhaps I can add a fourth, which are the ones that are involved in litigation. So the companies, because they are eventually worried with reputational damages that litigation might bring. And that's one form of impact. So let's say there are different actors there that are interested in impact. We so far don't have one way to measure impact, or not even a paper that has been published that lays out a framework of different types of impact and how to understand impact. The way we tend to talk about this is that there are direct and indirect impacts. So direct impacts being, you brought the case, you have the decision sets A, B, and C, and then you can track the impacts of that decision. So the decision said that you had to submit information on your emissions, you had to reduce your emissions, and you had to communicate something. And then you check if that happened, and therefore you have the direct impact of the litigation onto the decision, onto policy. Then you have this vast world of indirect impacts, which is, for example, what we just were discussing before. A company receives a letter, and that changes some internal process. And there is a case that has been filed challenging BP for greenwashing. Therefore, all the other carbon majors, before they decide on their next advertisement campaign, they want to really think carefully, are we at risk of being sued for greenwashing? So, that kind of anticipation of a risk. And then a really wider type of indirect impacts, which is are legislators thinking differently when they are writing the next law in terms of reducing the chances of litigation? Are regulators changing their policies? Is civil society believing more or less on the power of law? And the kind of I can go on and on and on in terms of many different types of indirect impacts that can be more or less quantifiable, but in general, we still have very little publicly available research showing us what these are.
I can give you a few specific examples. The most important US climate change decision was a case called Massachusetts versus EPA, a 2007 decision from the US Supreme Court that held that the existing Clean Air Act authorizes the Environmental Protection Agency to regulate greenhouse gases. And that came out under under George W. Bush, but when Barack Obama became president 2 years later, he very explicitly relied on that decision as the basis for the actions that EPA took throughout his administration. That was one very clear impact. Another is that the New York State Attorney General in the late 2000s announced the investigations of several electric utility companies over their disclosure or failure to disclose climate change risks in their securities filings. I think that quite clearly led to a change in the practices of many corporations and what kinds of disclosures they were making in their securities filings. But then when there was less enforcement, that kind of disclosure dropped off. And I think we're seeing it come back as under President Biden, the U.S. Securities and Exchange Commission is starting new actions there. Another example, and it's more difficult to trace, but in the U.S., there's been a tremendous amount of litigation against fossil fuel facilities, especially coal-fired power plants, and also natural gas pipelines. And we've seen almost the end of the construction of new coal-fired power plants in the United States. Partly that's because of market conditions, but partly it's because anyone who wants to build one knows that they will be immediately hit with a massive amount of litigation, that there are going to be very tremendous expenses and delays associated with that. So that's another instance where litigation has a real impact. One very tangible effect is the Supreme Court of Nepal indicated that the Parliament of Nepal should adopt a climate change law, and it did. They carried out the direction of the court. And it's also my understanding, Joanna would know more about this, that some very important decisions in the Netherlands and in Germany seem to have an effect on those countries' climate change policies.
Right, just jumping for a clarification, Michael, you mentioned the disclosure of power plants in security files. Can you just say what that is? Because that sounds like a very specific terminology.
I'm sorry. It would be in the, every publicly traded company needs to file annual reports with the regulators and with available to investors. And the question is, did these companies in those disclosures talk about the climate change impacts of their activities?
Very interesting. Thank you.
Mm-hmm. Yep, indeed. Go.
So if I can just follow up with the two examples that Mike mentioned in the end, the German and the Dutch examples, they are indeed very good examples of how very quickly, particularly in the German case, a decision in court reflected in change in legislation. So the German case is the Neubauer et al. Versus Germany case, which was recently decided by the German Federal Constitutional Court. I think it was in April. And that had, of course, immediate implication, not of course, because it's not obvious, but it had immediate implications in Germany. It was a matter of, I think, weeks until the German cabinet approved proposals that raised their climate mitigation targets to net zero greenhouse gas. And so that was really kind of represented an increase in ambition beyond even what was required by the court, but it just followed the decision very quickly. And then not only how that, of course, affects Germany, but then how other countries and litigators are following what's going on, for example, in a decision like that, and aim for a similar type of case and a similar type of decision in their own jurisdictions. And all of this can be pretty much traced back, first to the Massachusetts versus EPA case, which Mike mentioned, but then more recently to the Urgenda case in the Netherlands, which is of this kind of new wave, more modern wave of climate litigation against the government. The first one where a court told a government to reduce emissions, and legislation and policies followed to enforce that decision.
And I think one thing that shows is there's an important relationship between what the courts are doing in the country and the politics of the country. One reason why the decision by the Federal Constitutional Court in Germany led so rapidly to legislative action is that the politics of Germany were amenable to that kind of thing. The country was ready for that. Similarly, in the Dutch case. In the United States, when Massachusetts versus EPA came out, we had a Republican president who did not want to act, and we did not see any action. But then when a Democratic president was elected, he did want to act, and he used it. So these lawsuits need to be viewed in the context of the politics of the country in which they take place.
Absolutely.
Very interesting. You've not mentioned specifically an example on impact of these greenwashing type of cases. Can you maybe also elaborate on that one?
Yeah, I can start. Oh, sorry, Mike.
Okay, go ahead.
I'll start and then you compliment. I really have to say, I really enjoyed this format of dialogue. We had so many webinars where, we present, one person presents, the other presents, and then you have the Q&As, like a bit all over the place. It's a great format. So well done, organizers, for that. It's very enjoyable. At least for the speakers, it's very enjoyable. But in terms of the greenwashing cases, this is one of these recent trends that we are starting to observe now increasingly. Of course, greenwashing is nothing new. This term exists since the 90s, when companies started having more of a green discourse or action, and very quickly many observers, NGOs, watchdogs started noticing that there was a lot of kind of looking good but not doing much. So this is one thing. You identify that disconnect between what you're saying and what you're doing, and you call that greenwashing. Then there's a second moment where you start bringing greenwashing cases to court or to specific different regulatory authorities that look into consumer protection in different countries. All of that with kind of general environmental issues. What's more recent is that you started seeing that with climate. So with climate commitments, net zero specifically is going to be the new one, because we're seeing an increasing number of companies doing that. But the climate advertisement communication and miscommunication is, of course, newer. And then even newer is challenging this type of issue in court or different fora. So this is my first point, just to situate that that it's something that goes back many years, but specifically climate washing, you could say, is quite new, and specifically climate litigation for climate washing, even newer. So the cases we have are now in a few jurisdictions. It could expand because most countries have some sort of Consumer Protection Act and process to address those. So I would imagine that it's a matter of time to start seeing more. The ones we have, for example, in Australia and are interesting in the US, but particularly there is a wave of complaints that have been filed by NGOs before OECD focal points. And that's an interesting strategy, because these OECD focal points, while the decision, it's not a judicial forum, but what we've observed is that many NGOs have preferred that route because it's quicker, it's potentially cheaper, and in terms of creating that their communication strategy, they're increasing a litigation risk, it has apparently proved to be effective. So I wanted to raise that too, that this is an area that we are not only seeing judicial cases, actually we're seeing less of those and more of the type of complaint to the OECD focal points.
Yes, and this is one of those areas where there's a lot of activity under the surface. I still advise some clients privately, and I can tell you that there are a number of clients who are really paying attention to these greenwashing claims and have become very concerned about their own public statements. It really is having an impact. One interesting development is a few months ago, several Greenpeace associated groups filed a complaint with the U.S. Federal Trade Commission, which regulates unfair advertising and other things. They filed a complaint saying that Chevron was misleading in some of its public statements about climate change. And the Federal Trade Commission has not yet acted on this, but I think that more similar kinds of petitions and complaints may be in the works, and especially as we see more and more companies making claims that they're going toward net zero emissions or things along those lines. A lot of definitional issues, just what does net zero mean? There's going to be pressure on the Federal Trade Commission and the regulators in other countries to come up with more precise definitions of that, so that it's clear when that kind of claim can legitimately be made. But we've just in the last year or two, we've seen a proliferation of these kinds of net zero claims. And I've also seen it about LNG, liquefied natural gas, other things. There are real questions about that. So I think these kinds of claims are going to, as a greater incentive for corporations to make these kinds of claims, there's going to be greater pushback from NGOs and possibly from regulators against these claims and trying to make sure that they're really legitimate.
Sorry, a very quick follow-up on what Mike said. We just had the first case challenging a company on their net zero commitments that has been filed by an Australian group against Santos in Australia. And so exactly that, I think that's a first of many more. What is also interesting, I think this makes me think, is that if these companies do nothing, have no targets, no commitments, don't try to align to Paris or domestic legislation, there will be lawsuits for inaction. If they announce more than what they can do, or they try to, or they don't get there, there is also a risk of litigation. So I wouldn't like to be an oil company these days, because you're basically suffering from every direction. If you don't do, you will probably have a risk of being sued. If you say more than what you're doing, definitely. So there is, I think it's a difficult environment for them to operate. So again, I would like to be in their place. But in terms of accountability and governance, it is really fascinating how litigation has been raised to that point of creating a whole new level of accountability and governance in not only state, but also corporate.
Very interesting. I'll hand the floor back to my discussants in a minute. I just wanted the clarification, these OECD focal points. Can you elaborate what that means? So that's not like a normal litigation case, but what kind of power does that give?
Yeah, so the OECD focal points is it's not a court case, so it's a complaint that can be filed. Different countries will have these focal points of the OECD, and they respond. They are part of this broader guidelines of. So I always forget the name. Guidelines of responsible enterprises. I forget the whole name of the guidelines. Sorry, but there is the OECD has this statute, which is a guideline for responsible enterprises. And what you usually see is that they have then national focal points in different countries, and these complaints will be filed based on the disrespect of these guidelines to the national focal points. The decision, whatever is given, is not legally binding as such, but it has a kind of a soft power in them. So it's not that you will have to pay fines or go to jail or anything like that if you don't follow, but it tells, it can tell, for example, as it has been asked in the BP case, that advertisement campaign is inappropriate and unlawful. What is interesting in, for example, this particular case of the BP greenwashing is that before the OECD focal point in the UK reached a decision, the company BP decided to put down their campaign and agreed that basically the case lost its object in that they stopped the campaign, and sometimes you will see that happening too. So it can have an impact or a resolution even before a recommendation is made, but if not, it will get to a final recommendation.
Very interesting. Our audience is helping us, saying it's the guidelines on responsible business conduct.
Thank you.
Great audience.
Thank you.
Dear
Thanks,
discussants, you can fire your next question.
I think perhaps it's time, as we're basically like over the half of the event, it's to invite the audience to post your questions, because the idea is not only us, but ideally it's to give as well your chance to address questions to Joanna and Michael, and in this very friendly space and environment that we're discussing. So while you are receiving questions, I'm addressing another one, and perhaps could be a nice follow-up, because Mario was asking about the effects on the corporation, on the behavior of corporations. But let's get back to governments, and perhaps what I wanted to ask is not necessarily the effects, but perhaps a chance of side effects, and look at the specific cases that you are against governments in which Joanna mentioned they could be systemic, or they could address a specific legal act, or is even like an authorization to a third party or a company can be revoked in this case. You could think a possibility of this kind of climate change litigation have a side effect, a counter effect of foreign investment disputes. And I was reading in the report, your report, Joanna, about the definition used on climate change litigation, and for me it was not clear to what extent foreign investment disputes in arbitration courts could be covered by the database, and to what extent you could see this kind of disputes in rise if you look at them, and to what extent it could be a threat to this wave, or I would say the good wave of climate change litigations.
So our litigation database only includes cases that are in courts, that are in judicial forums. Okay. It does not include cases that are in arbitration. However, I'm going to let Joanna speak to that, because I agree that that's a big issue. Joanna?
So this is a new collaboration between the Sabin and Gerrard, and so together with Corey, we identified a number of 13 cases of that has been of investor dispute settlement. And we have now included those into the data, both Sabin and Gerrard's database. So it's true that until recently we didn't have those, but then because we started observing an increase in these cases, and particularly after the RWE versus State of the Netherlands dispute, we spoke to our colleagues at Sabin and said, well, let's try to include at least some of those cases. And I say at least because of two reasons. First, because many of these arbitration cases are private and confidential, so we don't have access. Secondly, because many of these cases are not very directly climate cases, not explicit climate cases as those that we try to include in the database otherwise. So for that, we opened a bit of an exception of the methodology that we would usually use to include domestic litigation, but we did then include 13 of such cases. And we did an initial analysis, and we have published a joint blog between the Sabin and Gerrard, where we look into those cases and see the differences between them. We of course comment on the RWE case, which addressing to your question it's an interesting case, because basically what happened there is that the German energy company RWE brought a claim for compensation following the Dutch government's plans to phase out coal by 2030. So the Dutch government was asked to phase out coal also as a consequence of the agenda decision. So they follow the decision, and then they have an energy company suing them for doing that. This is again where I said it's not a good moment to be a government or an energy company, because you're attacked from all directions. And so this in particular this case in particular shows that direct maybe relation between domestic litigation and how that can come backfire in such arbitration. But we have in that group of cases that we identified different ones. So I can post here on the notes the blog that Sabin and Gerrard wrote together, and you can see those cases now on the database.
And because so many of these are the ones that are publicly known, so many of these disputes are private and are not publicly known. There may be a lot more of them than we are aware of, but it is a potential negative side effect of some of all of this, and it has the potential to get in the way of some national efforts to phase out, particularly fossil fuel facilities. If a government takes action to shut down a pipeline or prevent a pipeline or from being built or something, there can be arguments that this violates investment treaties.
I'll propose also that we will just update the webpage of this event with some of these key references that you have been mentioning and a few key reports and papers from you, because I'm sure many people will want to follow up, including me. A new world is opening up to me, I must say. So, Mario, are you going to ask a next question?
Yes. Of course, we are a few weeks or away from the COP26. So I can't avoid asking a question on also with regard to the COP26 that is going to take place in Glasgow. And I want to ask you to what extent climate litigation can have, in your opinion, an impact on negotiations that are going to take place in Glasgow, or to what extent already climate litigation already had an impact on previous negotiations during the previous COPs. Yes, thank you.
Well, I would start by saying the most important decisions on climate change are not made at the COPs. They are made in the national capitals. The negotiators at the COPs are agents of their governments, and they can only do what the governments authorize them to do. Litigation does affect the policies of some national governments, as we've just discussed, with respect to Germany and the Netherlands and Nepal and that kind of thing. And that's the chief mechanism by which litigation affects what happens at the COPs.
Yeah, I think I can try to add a few points. One is that there is an issue in the climate negotiations that has been quite contentious for a long time, which is loss and damage. And of course, states are trying to run away from having any responsibility for financially paying for loss and damages. And this is an area where litigation has tried to a certain extent to, outside the international agreements, bring advance domestically, particularly in the US with the liability cases. Of course, they're not framed as loss and damage. And of course, in the loss and damage negotiations around loss and damage, you wouldn't hear the negotiators speaking about litigation. But there are papers and research that have been exploring how these two might complement each other, or how litigation might be trying to address that failure, or that's not failure, but a place where the international negotiations struggle to get. The other point, I think, that there is this indirect, again, it's never direct presence of litigation within the negotiations, but is that we are starting to see an increasing conversation and risk of, and more recently with the Vanuatu petition, an increase of having a case brought to the ICC, the International Criminal Court in The Hague. And this is something that until recently we hadn't seen, one state filing a climate case against other states, but that's, which is kind of politically quite complex, but that we might see soon with this, with the Vanuatu recent developments. So again, it's not something that I imagine negotiators will be talking about at COP, but that that is happening in the background and is of course, gets attention, and it's at the back of people's minds.
Thank you. Very interesting, Joanna. We have a very nice question from the audience, from Gabriele, who asks, I am curious about the ethics surrounding how climate science research is funded and the role of scientists in the litigation process. Would you mind speaking more about how research and scientists support these cases, are chosen and deemed unbiased?
Let's say most climate research is, is funded by governments and some by private foundations. And in the climate litigation, usually what happens is there are citations to the Intergovernmental Panel on Climate Change and other research bodies. Very little climate science research, original research, is funded by the litigants, by the people who are on one side or the other of the cases. And there's been very little litigation challenging climate science itself. That in almost all the cases, the findings of the IPCC and other groups of that sort are put forth. They're summarized by scientists who may be retained by the lawyers, but they're not challenged by the other side. I think most litigants realize that if they tried to challenge the underlying science of climate change, they would lose. That's not the grounds on which they litigate. And so I think the ethical question that is implied by the stated by the question doesn't really arise. You don't have situations where you have scientists who are paid by either the plaintiffs or defendants in these cases who are just putting forth science that might be biased by their funder. That's not where the science is coming from.
Yeah, Mike gave a very good answer, and I think I would just add an angle to that, which is it's interesting how there is a role for science in litigation, and how that has. I think there are two things happening in terms of use of science. One is, as Mike said, kind of the understanding of what's happening, that the science has been consolidated. The IPCC has become a source for many of these cases. For example, the Urgenda case already did that, and then especially following the 1.5 report and now the new assessment report. So you can see how courts have engaged with the particularly with the IPCC, and there's almost no questioning on whether the problem is happening, whether those companies contributed. Even there's some really interesting examples in the US where the companies already say, yeah, we know that the climate change is happening, we know that our activities contribute, but why do we have to pay? So that then when you get to that missing link of the attribution, this is where we see science becoming quite crucial in a number of litigation. And you see how climate attribution science is a body of science that has been developing for a decade or so, even more, a decade. But there is a use of that, of those papers, of those findings in litigation. So I think what is interesting is that you have to now, in some cases, really have some translation of the science into cases, and that requires a really know-how and knowledge from those bringing the cases. Is you can't, there are thousands of papers out there. What are you bringing? How are you saying? What are you saying? That becomes crucial. But the science is out there, and it's a matter of how it is translated, explained, and what is brought into the case that is interesting.
So some of these scientific issues may be litigated in the future, depending on how far these cases go. So in the US, we have, as discussed, a number of these cases brought mostly by municipalities against energy companies, saying that the fossil fuel emissions are causing sea level rise and requiring the companies to spend a lot of money on seawalls and other protective devices. There are a lot of preliminary procedural issues that these lawsuits have to survive. But if they eventually survive them and we actually get to litigation on the merits, which hasn't happened in any of those cases, there will be disputes about just how much sea level rise was caused by what, and what are the necessary protective measures. Those will be interesting, disputed scientific issues. But the underlying idea that humans are primarily responsible for climate change and climate change has serious impacts, nobody in these lawsuits is disputing that anymore.
Thank you. You are getting compliments from the audience. They're all fascinated. So I think you've really touched upon a topic where everybody wants to know more. And the good news is next week we have another debate where we will come back to this topic, but from a specific perspective of what it implies for energy regulators. For instance, a regulator that has to balance, impact on climate with, for instance, security of supply when making certain, infrastructure decisions or any other regulatory decision. So let's use the last minutes we have here, because we promised to stop nicely on time, to just allow Joanna and Michael to, what are your thoughts we should take away for the debate next week on that more specific topic?
Well, I'll just say there have been two very interesting developments just in the last 2 days. The International Human Rights Commission, the United Nations Commission on Human Rights, issued an opinion that there is a right to a clean environment for the first time. And then just a few days ago as well, the United Nations Commission on the Rights of the Child issued a decision in a case and found that a country is responsible for the impacts of its emissions in other countries, of its greenhouse gas emissions. So we're also seeing more attention in these human rights tribunals to climate change and the effect that it has on the rights of people. And some the national courts of some countries, not the US at least so far, but in some other countries, are taking these human rights issues very seriously. They're in countries that have joined into the European Convention on Human Rights or other international human rights conventions, and that can begin to have a real impact.
Yeah, I think from my side, my last words are one, that this field has evolved so much in the last 5 years. It is really an area that there's rarely 1 week now that we don't have some really interesting new case filed or a new decision, or so there's a lot going on, and so it's a fascinating area to follow and study more. But then I guess, and I want to link to Mario Pagano's PhD thesis, which is, this is one way of mobilization, is one way of legal mobilization. But of course, I don't think any litigant or court is expecting to save the world with litigation. This has to come alongside so many other actions, innovation, and other developments in society. So of course, we think this is amazing, but we have to put it in this one piece of a larger puzzle.
Thank you. We're exactly on time. So I'll just repeat once again how great you've been. Really, thank you to both the discussants and thank you to our two experts. You have really, really been great. The dynamic among you is also very nice to see. So I can understand why you're working together on this database and everything related to that. And as you can see here, it was already mentioned, right? Next week, we have a topic that is quite close to this one, more specific, getting deeper into regulatory responsibilities, right, on this energy transition. And then even more, we have, as you can see there in November, additional events together with the International Association of Energy Economics. That's it for now. And I hope to see you back soon for another episode of FSR Insights.
Thank you very much.
Bye-bye.